I think that I needed to also touch on the other two questions that were raised, which we did not respond to. Firstly, I would have loved clarity as to the messenger that might be pursued, because there is a report, somebody who compiled the report, and there is somebody who should have reported. So it is not very much clear as to whether the one who was obliged to report could be seen as a messenger, or the one who have compiled the report, who is the messenger. Otherwise, generally, what we do is we don't pursue any individual. We look at the crime. And it can be seen from the case of Tlhagudi and others that we have arrested in Eskom, involving 745 million rands. And that matter is ready. If Mike Lomas, who is now sitting in the UK, can come back and come and join others in the dock, then we can see that matter progressing. So at this stage, it seems that these things will move slowly, but there are other people elsewhere who are delaying this. He ran from another country in the UK, and then he's challenging all of the processes in court to exhaust, to avoid coming back, to come and join others who are now in the dock. These matters are complicated. That's why they at times take time. In these specific matters, there are 426 statements that have been filed. It is the work that the people have done. And the charges is 95 counts in one matter. So we normally talk about one matter, but when you open, that matter is voluminous. The second question was the naming, the question as to whether certain names come in the report. And I think that the author did not mention in the public arena as to who are listed in the report. And from the DPCI, I think the practice has always been that we mention when we charge, not at the time of the investigation. That's why even when we talk Steinhoff, I normally prefer to talk of Steinhoff, not an individual who has not been charged. Obviously, it is not for that matter that we are dealing with today of Steinhoff, but there are other countries that are also delaying us, that we need evidence from those countries. And some of the countries obviously are proceeding, but we wait information from those countries to come. Otherwise, we will be only prosecuting a certain portion, and we leave some of the counts that are supposed to be included. The last question of the resources, I think that we have been vocal on this point of the resources. We are currently sitting at 52% of the capacity. So obviously we are building on this, and then I think it becomes apparent that the volume of work that we have, which is more than 22,000 cases, require more hands. So when you have got that number of dockets on hand, it means that the pace of finalization of these matters may need a little bit more time than if you have got more hands. Thanks, Chairperson.
Thank you, General De Beer. Yeah, so resources are constrained in the country, and largely because of the bailouts of Eskom and all these other things, and malfeasance all over the place. So, Mr. Chairman, I'm not sure how we go forward, because Rule 168, I'm becoming a Beki Khatebe here now, Honourable. But that rule gives us
You're on way forward now.
eh?
You are getting into way forward now.
It
Hold it
provides privilege for us as members, but it equally provides privilege for the people appearing before committees. And so therefore, it's my opinion, and I'm going to have to take legal advice on this, but unless you want to rule...
On the way forward, eh?
No, it's not the way forward.
Okay.
It's about... I'll get to that. It's unless you're going to assist me by ruling, but it's my opinion that both Advocate Matibi and General Lebeya are obliged to answer my question about whether the name of David Mabuza appears in the report. So it's up to you, Mr. Chairman, to make a ruling. Otherwise, we'll check from a legal point of view where we stand. But that's certainly our opinion, is that there is there's no escape for General Lebeya and Advocate Matibi but to answer the question given the status of everyone in this meeting. Thank you, Mr. Chairman.
I think let's accept what has been the standing rule from their side, NPA and everyone involved in terms of investigations. Allow them to finish whatever they do, and when the time allows, they would be at a stage where they would pronounce the names involved on a matter. Even the court of law, up until people appear at the courts, there's no way that you would name those individuals. So let's allow that kind of a process. It's fair, because you'd name people in an allegation which is not proved, and you damage individuals. And I think let's allow fairness into such kind of a standing practice. I want to plead with the committee around such. At the right time, definitely would know and insist to know.
Thank you for your ruling, Mr. Chairman. And I don't accept the substance of it. I have to accept your ruling, though. So absolutely.
Do I want to?
No, just clarity on. I think Honourable Lisa referred to Powers, Privileges and Immunity Act. My understanding, Chair, on that aspect, if a person appears before the committee, that person, for him or her to be protected before the start of the meeting, you must take an oath on affirmation that whatever you say, you are. Yes. So if you have not taken that, then you are not covered. Remember when we dealt with. Remember when we dealt with Mr. Andre de Ruyter, and he refused to take an oath and affirmation. He was therefore not protected in that aspect. So we can't, in the middle, towards the tail end, want to invoke that which you have not administered at the start of the meeting.
Out of order. Well, I've ruled on the matter. We go to Honourable Makaba. Honourable Makaba.
Yeah.
Chair, thank you very much. But I just wanted to make a comment on the ruling. But I understand you've just made a ruling. But I think on this matter that is raised by the member, we need a legal opinion, because there's two folds on this thing. There's an issue of us in the scope of having a jurisdiction to get the information that we need, and from the legal side, they have their legal opinion in terms of not disclosing the names before they are being charged. So I think we need a legal opinion on this matter. I hear that you have made a ruling on it, but I think we should take that into consideration. because I think we should then separate about which one overrides the other in this instance. And then my second question, Chairperson, firstly, I just want to commend the committee, the department rather, on the recovery of the 1.577 billion. That's very progressive in terms of the matter of the case. And then my second question, Chairperson, is on the issue of the Hawks report on page 7, where they are mentioning the issue of intimidation and the threats and the violence on the ESCOM members, where it further mentions that there is also extensive and life-threatening intimidations that have been raised towards the ESCOM employees. So my question is that as part of the investigation, I want to know is if there are any measures in place to make sure that these people are protected, the ESCOM employees who are being life-threatened. We all know, sitting in this room, that there's a lot of cases other than this case whereby whistleblowers have been assassinated to destroy evidence. So that's my first question. And then the last question is on slide 13, on the issue of the 85 entities that have been taken to administration in terms of referrals of SARS and blacklisting. I want to know if there is a list of those names and if they can be also made public. Chair, I think I'll end there because the other two questions have been mentioned, have been responded to, the issue of the 32 cases that were not in the jurisdiction of the SIU. Thank you very much.
Thank you very much. Can we start with General?
Thank you, Honourable Chairperson and Honourable Members. Ours is regarding the witnesses as to whether there is a protection of those that are being intimidated and the threat made to them. We generally take this on a case-by-case basis. It may also have appeared in the media not so long where somebody else have been indicating that there are these threats and the like. And we engage each individual, each witness. And even those that came before the media, we engage them. We explained how the system is working. And those that are prepared are actually taken into the program. I think that the individual that may also have come in the media in the recent past, we engaged and offered. Unfortunately, the people do not always come back and inform the public through the media that this is what have transpired. I was actually offered to be taken into the system for the purpose of protection. So we take it on case-by-case basis. So in terms of the report, as indicated in the presentation, is what we extracted from the FIVA's report, that there are this type of threats. But whenever the individual witness require that, we take that into consideration, Chairperson. Thanks.
Thank you, General. Advocate?
No, thank you, Honourable Chair and Honourable Member. With regards to the companies that have been referred, we just really didn't detail them because the focus today was on the FIVA's report. But otherwise, we can, as a team, compile that list, and in conjunction with National Treasury and SARS, and see and refer it to the Secretary. Thanks.